I'm Bahauddin Mujtaba, and today, along with my colleague, Professor Frank Cavaco of Nova Southeastern University, we basically try to give you an overview of corporate wellness programs and some of the implementation challenges that managers, human resource professionals, and obviously employees and employers need to be aware of. We tend to caution employers to be very, very careful when creating and implementing wellness programs, since there can be many laws, statutory, regulatory, and common laws that can apply to wellness programs. And today, you're going to see an interview with Professor Frank Cavaco, who's going to expand on these issues over the next few minutes for you. Is there a generally agreed upon definition of a wellness program?
No, there's not, and that's surprising since so many corporations now have wellness programs. There's no set management definition, HR definition. There's no set regulatory law definition. A couple of courts have made some general pronouncements. Just speaking very generally, one can say that a wellness program is a corporate program, and it's designed by a corporation to improve the health of their employees, but with a very practical additional goal in mind, and that is to reduce healthcare costs.
What would be some of the legal challenges that corporations should be aware of?
Well, there are a lot, because there are a lot of laws that can arguably apply to corporate wellness programs. There's a statutory law, and there's the common law, there's federal law, there's state law, there's congressional law, and there's regulatory law by government agencies. I'll just go down through some of them very briefly, because there is so much. And remember, these statutes are here, but the application to these statutes is not yet occurring. So there'll be cases and regulatory decisions in the future. I guess we can start out with the most basic statute. That's Title VII of the Civil Rights Act, which prohibits discrimination against employees and job applicants. So you better make sure that your wellness program does not discriminate against employees or job applicants based on the protected criteria, race, color, gender, religion, national origin. But also you have to aware, what if your wellness program has a disparate adverse impact? In other words, it's neutral on its face, and it applies to all the employees, but it has a disparate impact. Say it applies to smokers. Well, maybe smokers are less educated people, less educated employees. What if they're minorities? So what if your wellness program has a disparate impact on minorities? Well, that triggers Title VII and civil rights law. Age discrimination in employment. No discrimination against older people. Well, you have the same standards. They apply to all your employees, but they may have, once again, a disparate impact against older employees who may not be able to meet those requirements. So maybe you should have some differing standards, not only for legal, but also for moral grounds for older workers. And then once again, if there is that disparate impact, there is a defense, reasonable factor other than age. We can save that for another day. And whether a reasonable factor other than age is a reduction in health care costs is a good question. I don't have an answer for you, but I'm sure we will get one from federal district court, then a court of appeal. And that's, as I said, it's a challenge for the employer. You don't want to be the test case for a reasonable factor other than age defense when your wellness program has a disparate impact on older employers. There's the Americans with Disability Act. No discrimination against people with disabilities. What if smoking is an addiction? That's a recognized disability. What if your weight is due to a thyroid problem or genetics? That's a disability. That triggers the ADA, which also requires accommodation to the disabled employee or job applicant. So an employer has to worry that its wellness program doesn't discriminate against the disabled who have a disability in the form of perhaps weight or smoking, and also, as I said, that they make a reasonable accommodation. And then there's state law. One example, many states in the United States have state lifestyle protection statutes, which allow the employee the freedom to engage in a lifestyle of his or her choosing, assuming that it's legal. Well, what if my lifestyle is a legal but unhealthy lifestyle? I eat too much, I drink too much, I don't exercise, I smoke. As a matter of fact, since Colorado has such a statute, I not only smoke tobacco, but I also smoke marijuana, which is now legal under the Colorado referendum. Recreational use is legal. So I have a very unhealthy lifestyle, and proud of it. And I may be legally protected. However, these lifestyle protection statutes say that an employer can penalize an employee for an unhealthy lifestyle, even pursuant to a statute, if the employee's unhealthy lifestyle would be detrimental to the business interests of the employer. And here, of course, the business interest could be what? Healthcare, the rapidly rising healthcare costs. And so we don't know, though, because there's no case. And so you said, what's the challenge? The challenge of the employer, don't be the test case. Be very careful what you do. And then still under state law, there's the common law tort of invasion of privacy. I mentioned that you don't want to immorally, unethically invade your employee's privacy, or you certainly don't want to commit that tort violation. That's an intentional tort with damages for pain and suffering and punitive damages. So you better make sure that you don't disclose any confidential information about the employee. And then there's the tort of intentional infliction of emotional distress. So all right, all the employees and everyone on the scale, do that in front of everyone. Let's publicize everyone's weight. Not only may you have an invasion of privacy, but under the old common law, if an action is regarded by the community as atrocious, outrageous, and granted it's a hard standard to meet, but, you know, put some people on a scale, and they're going to consider that pretty outrageous, as well as humiliating and embarrassing. So employers have to watch out for, as I said, federal law, state law, and the common law.
Well, thank you very much. Are there any other suggestions for human resource professionals, managers, or employers regarding wellness programs that...
I think, my first suggestion is get expert legal counsel. Do that right away. And then obviously you want HR professionals too who are well versed in this field. And then naturally you want to deal with medical and healthcare professionals. As a matter of fact, one recommendation would be basically outsource your wellness program to some third-party provider, a licensed provider of wellness programs with licensed healthcare professionals. The idea is to try to establish a culture of wellness at the workplace. Meetings, nutrition counseling, positive type of events, and people can report on their success. I think that's the best way to approach things. As I said, be very, very careful when it comes to privacy, diversity, sensitivity. And as I said, those HR professionals, not just dealing with wellness and health per se, but also for these other pertinent areas, sensitivity and diversity. And I said, with the ultimate goal of having a positive workplace. A culture of health in the workplace, so the employees will feel good about themselves, and they will get the rebates, the rewards, and the employer will also feel good because the employer's health care costs will be reduced. And as we like to say at business school, all the stakeholders will benefit.
Thank you very much.
My pleasure.
So in terms of practical recommendations, the wellness plan must be properly structured to be legal, to be ethical, to be moral for all employees. And we need to avoid any direct or indirect forms of discrimination when creating or implementing wellness programs. Creating and implementing a wellness program can be very beneficial to the employers as well as to the employees. The goal is to be fair to all employees and to always act legally and ethically. So encouraging and motivating employees to get involved in various wellness programs using either carrots or sticks tend to produce positive results for their stakeholders. You are the driver of your health and the quality of your life. The goal is to be a good driver and live an enjoyable life. So get a good physical exercise regimen set up for yourself, maybe 3 to 4 times a week. Go out there and exercise, eat a proper diet, and obviously stay healthy. People with healthier lifestyles are expected to live an average of 6 to 9 years longer. So if you're getting a good exercise, obviously you will live happily and a healthy life, and you'll enjoy it more. Good luck, and be a good driver.